Good evening and welcome to Tee It Up Talk, real relevant and applicable conversations about today's hot topics and more. Excited to have on with us today Attorney Corbett and my good friend Keith Wiggins as we step back and just kind of reflect and have conversation regarding the Breonna Taylor decision that was handed out a couple days ago from the Attorney General there in Kentucky. So, without further ado, Attorney Corbett, we'll start with you. I think probably um, the one thing that can possibly set the tone for the conversation is just from your legal mind. Can you help us or kind of walk us through the decision that was laid out from a legal standpoint?
Okay, sure. So you have the incident that occurred with Breonna Taylor, I think occurred on or about March 13th of this year. Police had obtained a no-knock warrant, and a no-knock warrant is a search warrant which allows officers to enter and search a person's home, who they are. Ms. Taylor's former boyfriend had already been arrested, and police had obtained a warrant, and the information they provided to the judge was that a couple of months prior someone had been seen at the apartment and receiving a possible drug package. Prior to them serving, though, the warrant, they received information that Miss Taylor was called a soft target, meaning that she's not the main person that we're looking for, and that they're only looking for money and or drugs, possibly in the apartment. The warrant is served shortly after midnight. There's some discrepancy as to whether the officers announced themselves as being police officers or not. They say they did, which with a no knock warrant, they don't have to, but they say they did anyway. Mr. Walker, who was Miss Taylor's boyfriend, indicated that he heard knocking or banging at the door, but never heard anyone say that they were police. And there were witnesses who live nearby. I think maybe two, at least two, said they didn't hear anything, and one said he initially, after being interviewed twice, said he didn't hear anything, and then the third time said he did. But you had the three officers, Mattingly, Cosgrove, and Haskins. They burst through the door. Officer Mattingly is the first one to go through, and he stated that he saw Mr. Walker, Miss Taylor, and that Mr. Walker had a gun, and Mr. Walker fired one shot, excuse me, and struck Mattingly in the leg. Walker does not dispute about firing the shot. Um, Cosgrove fired as well, and Haskins fired as well. Haskins, though, shot through a window or sliding glass door. Of the three officers, only Haskins was terminated. The other two, I think, were reassigned. And of the three officers, only Haskins was indicted. Haskins was indicted for wanton endangerment. And in Kentucky, that is a Class D felony, meaning that you can serve from 1 to 5 years in prison as well as pay a fine. And Haskins was indicted because, pursuant to policy, I believe they stated he did not have a clear line of sight. He's firing randomly into a home, and that's clearly a violation. And he's the only one that was indicted. The Attorney General, I think, at his press conference, stated that there was discrepancy with the ballistics report. The Kentucky Police Department's crime lab was unable to conclude out of the three officers which one fired the fatal shot that killed Miss Taylor. The FBI crime lab determined that Cosgrove was the one who fired the fatal shot. And the Attorney General stated that because of that built-in discrepancy, that would lead to reasonable doubt if they had proceeded to trial. But he also stated they had already concluded that the officers, well, Mattingly, former officers, well, officers Mattingly and Cosgrove were justified in their shooting. So it didn't make a difference about the discrepancy in the ballistics report. So as a result, out of the three officers who shot into the home, only one was indicted, and he was not indicted for striking or killing Miss Taylor, he was indicted for shooting randomly into an apartment that could have injured other people.
Gotcha. Gotcha. So those are the facts as we know them. Those are the facts as stated by the Attorney General. So we appreciate you going through those facts and kind of laying them out for us. Keith, did you have anything before I jump in?
Yeah. So Rob, kind of based on what you know around those facts, and what has happened, do you feel that if this happened in a different locale, with probably a Democratic AG, that there might have been a different outcome? Or let me rephrase the question: what type of charges would have been reasonable based on the outcome of what we see?
Yeah, it's difficult because I think of it, and we all know, or deep down at least, like we all feel that if it had been switched, that if you have black police officers going into the home late at night, and you have a white couple, and the boyfriend shoots at police, then you're going to have gun rights advocates who are going to be champions. Say this is why we have the Second Amendment, to protect our home from things such as this. And then the officer had killed an innocent white woman. There's like more discussion about, hey, these officers should be charged. But even in that situation, regardless if you change it, from a prosecutor's viewpoint, I can still see it coming down a similar way. And the reason I say that is you have sort of competing doctrines or theories, legal theories that are taking place. For Kenneth Walker, he has castle doctrine, which means that you can protect your home. You're allowed to use deadly force in your home when you feel that you are in danger. So that's why, although they charged him with attempted murder, they went back and said, we can't do this. He could defend himself because he didn't know that these were police coming in. And then you have the opposite of police officers. If they are fired upon, they can use deadly force to defend themselves. And that's not unusual in terms of for a prosecutor to make that determination. The issue I think I have, though, with this case is the lack of transparency. We don't know all the evidence that the AG looked at. And without that, how can you say that he made the appropriate call? In other situations like this, you'll have the prosecutor kind of say, look, this is what we did. This is how we came to this decision. Or even locally, our elected DA has done that when he has chosen not to proceed on cases or charging police officers. So it's sort of hard to say in terms of what charges could come out. If it had been shown, though, that Haskins killed Miss Taylor, then Haskins could be charged with reckless homicide. Kentucky has 4 levels of homicide, and reckless homicide is one of them. And that would apply if he had been the one who killed Miss Taylor.
Okay. Was he the one that fired through the sliding glass door?
Yeah, he's the one who fired blindly without knowing what or who he was shooting at.
Okay.
Gotcha. So basically, the AG is saying that these individuals acted somewhat appropriately based on the law that was in place and based on their ability to utilize that no-knock warrant to enter the home of Breonna Taylor.
Yeah, and even like whether it was like the no-knock warrant part helps Mr. Walker in terms of for them to say, hey, well, if you don't know who it was, then that helps him. So whether it was a no-knock or not, then they're saying under the law, they have made the decision that they acted in self-defense. Now, what happens if you and I act in self-defense is we don't always get that benefit of the doubt. And that I've had cases of where I can say, look, my client acted in self-defense, and a prosecutor can say, okay, fine, you tell that to the jury, but we're not going to refrain from charging you. Excuse me. In fact, I have that now probably in a couple of cases. So, I mean, they'll charge you anyway, and then you have to wait and go through the process and the negotiations for them to either see it is self-defense or for them to say, well, no, I'm just not going to believe it and let the jury decide. With officers, though, they don't do that. They say, yeah, you acted in self-defense. that was reasonable and there's no need for us to charge.
So that's kind of standard for officers in general. That's kind of what you see across the board.
Yeah, I don't know if it's fair if I can say it's standard, but I
Okay.
get, well, maybe we can say that, because like there have been plenty of cases of where we see that officers aren't charged, or the delay in charging is because they are saying, look, I acted in self-defense, I had to do this, and then you have to go through a lengthy investigation before charges are brought, if they are, where it doesn't happen with lay people. Lay people, you get charged and then the investigation like continues. But with officers, they want to make sure they've done everything first, and then before they bring charges, which
Okay.
should probably be like that for everybody.
Right, right. And that's what I was kind of alluding, but I appreciate that. And I have a couple other lines of questions, but could you help us understand, or help everyone understand, the difference between the civil settlement that happened and what they were trying to pursue from the criminal case? Because I think what we're seeing is people are probably saying, well, these guys are negligent, but that doesn't always necessarily lend to some type of criminal case coming to trial, or some type of
Right.
someone being charged from a criminal standpoint.
Right. So, like for the civil suit, for civil versus criminal, civil, you're trying to get someone to stop something, stop doing something, or you're saying that you were harmed in such a way and that you're entitled to damages. So the city settled with the Louisville, Kentucky, settled with the Taylor family, the settlement being $12 million. I found that odd in that it was settled so quickly and before there was any announcement regarding criminal charges. And in addition to that, there was no non-disclosure agreement, meaning that a lot of times in these cases, there's an agreement that you can't talk about it and you can't say what the amount was, but you didn't have that here. So I did not think, based on the delay, how long it's taken, I didn't think they were going to bring charges. And once the announcement was made that they had settled, before they talked about charges, I was further convinced that they weren't going to be indicted. So I wasn't that surprised, based on the news conference or the judge saying that this was the only indictment that was returned.
Gotcha. No, that makes sense. I totally understand that. And um, so, from a legal standpoint, does the Taylor family have any other course of action that they can take to, one, possibly see the evidence that was presented by the AG, and or will there be any other options they would have from the? I think the FBI has an investigation going on as well. Is that an option that could bring some form of charges or take some things higher or to a different place from a legal standpoint?
So first question, in terms of, are they allowed to see the evidence? They can. There's no law that prohibits you from seeing it. But there's no law that says that they have to sit down, that the
Okay.
police department, FBI has to sit down with the family and show them.
Okay.
Can lay it all out and say, look, as this was a tough decision, I know people don't agree with it, but this is what we looked at. I guess he did that in part, but show it, hey, this is what we have, and this is why we came to that decision. Sort of like what the prosecutor did in Atlanta, and I apologize because I can't remember the man's name, who was at the drive-through
Yes.
and ran from the police and then was shot in the back. During that press conference, they laid everything out saying, hey, this is all the evidence we looked at. This is why we are charging for this particular crime. And, they could have done that, or it could still do that in this case, in Ms. Taylor's case. But you said, what recourse do they have? I don't really, civil side is done. I think Ms. Walker's, not Ms. Walker, Ms. Taylor's boyfriend, Mr. Walker, I think he's filed a civil lawsuit. In
Right.
terms of criminal charges, though, local prosecutor had already, I guess, declined it, since that's why the AG came in. Local police department didn't charge, so there's no reason to think they're going to charge now. No reason to think the local prosecutor will take the case. If the FBI is looking at it, they could potentially do a federal case, but then the U.S. Attorney's Office would have to pick up the case and say that
Right.
there's some criminal civil rights violation.
Gotcha. Okay. So now that helps lay out some of those pieces. And so I think a lot of the frustration then too is the lack of transparency because the AG has decided not to kind of lay all those facts out or all the things that his team presented to the grand jury. So that's pretty interesting. And so it sounds like more of the fight then is going to be around laws and legalities and making sure certain laws are in place or aren't in place so that some of these things don't happen in the future, i.e. the no knock. I mean, we can dispute whether the person knocked and they announced themselves or not, but it really didn't matter because they had a no knock warrant anyway.
Right.
How does that look, or are there any statistics that you know of around these no knock warrants and how successful they are, and or the types of tragedies that happen because of no knock warrants?
Yeah, I don't know the specifics off the top of my head. I do know that there was a list out there, and it talked about in terms of how many people have been killed, how many officers, how many civilians have been killed in serving no-knock warrants. And I don't remember the period of time, but it was double digits that I remember somebody quoting. There is a law in place, or there's a law in the state legislature in Kentucky, or it's been proposed to end no knock warrants. I think the Louisville Police Department has said they are no longer going to conduct no knock warrants. And this is in terms of, you had problems in this case before they even got to her home, in
Right.
that they shouldn't have been trying to use a no knock warrant when she is not the queen pin. They are not trying to apprehend a dangerous suspect. They are only looking to see if she had drugs or money somewhere in the home. Then you could have done that in the early morning hours, in terms of, you want to catch people, I guess, off guard. Do it at 4 or 5 o'clock in the morning when people are just getting up trying to go to work, or do it in terms of announce that you are police with the bullhorn, say, hey, police are out here. We need you to come outside right away, or we're going to go in. The information they had wasn't timely, in that it was
Right.
based on stuff they knew from maybe a couple of months prior. So because of that, I mean, so this is a buildup of all of these things coming forward, which is why they shouldn't even been there that night. And then you kind of look at it in terms of, that's legal what they did. But just because it's legal doesn't make it right. Slavery used to be legal, but just because something is legal doesn't make it right. And you have to wonder, would you have done this in other parts of the community? Like for here, we could say, look, you would do this on West Boulevard, but would you go to Ballantyne and execute a no-knock warrant when all you're doing is trying to see if somebody has money in the house? They probably wouldn't. So there's a
Right.
disregard maybe for certain people in the community, and that you're addressing that at the department, at their policy level, who's making those decisions.
Gotcha. Yep. So again, it goes back to a understanding or restructure or reform from a police standpoint or legal standpoint. Because I'm with you. I'm trying to understand how the judge granted these no knock warrants. It doesn't really. I don't understand that. To me, it's and I could be wrong, but it's once again one of those things where we have this quote unquote war on drugs, but the way we're waging this war isn't proper. And individuals that look a lot like us tend to get the negative end of some of these things that they're doing to try to quote unquote wage this war on drugs. But Keith, I didn't know. I wanted to lean over to you to see if you had any more questions or thoughts on something.
Yeah, I mean, just in the way that things have kind of shook out, I mean, you have the presumptions of being right by police officers, and then you have the presumption of guilt, and I'll just generalize, by people of color. And we're fighting this battle of trying to still have equal footing, just in getting our death investigated. And Rob pointed out how this had been, a different scenario, that we probably would have had different more of an outcry, a national outcry, in terms of the way it happened, and maybe some other organizations that would have stepped up and argued about it. But I mean, we saw the same thing with Philando Castile when he was killed in his car. The NRA was silent about that situation.
Right.
You know, there was a situation where Atiana Jefferson, and she was the woman that was killed when her nephew was playing games. They were up late at night, and a police officer came and shot her because he saw her with a gun in her hand. He was charged, but it was so blatant. And again, you know, this situation is one where, in my mind, and again, I'm not a lawyer. I did watch Law and Order last night, but I look at the case for criminal negligence and all of the things that did have to happen in order for them to get to this point. And I wonder if there's a case for that, because we can be found criminally negligent, like, you know, driving our car in, you know, vehicular homicide. Would that ever apply to the police, or are they just held or given such leeway that this shield of immunity they have prevents those things from happening? Is that something that's possible, or have you ever seen that happen with police officers, Rob?
Police officers charged with, I mean, and what example again?
Like criminal negligence, in terms of they just did so many things wrong to get to a certain point that it was a crime in and of itself.
Yeah, so it depends on, like I said, the state and the laws that apply. For instance, like in North Carolina, we have our criminal negligence is probably like the results in death is going to be an involuntary manslaughter. And that is that you are doing something inherently risky or criminally negligent, and it results in the death of another. But then you still have to apply the law to the facts. So if this happened in North Carolina, it's the same issue of would they be charged? They wouldn't be charged with murder, because that is the intent to kill, and it's specific premeditation, deliberation. So it wouldn't apply to murder, first degree or second degree. And then even if you looked at involuntary manslaughter, you're still butting heads with the, well, but if he's in the right if he's justified to return fire when he's shot at, then involuntary manslaughter wouldn't apply either. And so that's the same thing in terms of for Kentucky, in that you're weighing self-defense versus their version, which is reckless homicide. Could they be charged in terms of, like, it's all just like, I mean, you know, just people talking in terms of, you know, what they think. And then that's how a lot of criminal trial, I mean, that is what charging decisions are. It's prosecutorial discretion. So if that, you know, AG says, hey, I'm looking at reckless homicide and self-defense, and because these things are both present, I'm just going to opt not to charge. Another DA could say it's reckless homicide and it's self-defense. Rather than me make that decision, I'm going to charge, and I'll let the jury decide. And the jury comes back and says self-defense, so be it. But I'll at least charge, and, you know, and we'll go forward with the case. So, you know, that goes back, like, hey, who we elect to make those decisions and how important that is. That AG in Kentucky hadn't done criminal law. He clerked for Mitch McConnell and,
Yep.
you know, somebody else. And then after that, he joined a law firm in Kentucky and ran last year. But I don't think he's done criminal law. So he hasn't worked on these cases. So, I mean, that's important when you look at in terms of, you know, who we're voting for.
Right. Go ahead, Keith. I'm sorry.
Yeah, that's a good point. Because with our elections coming up, I mean, how do we vet, you know, who we're actually voting for? Because so many times there's so many names on the ballot. You know, you don't necessarily know who you're voting for. You see a name, sometimes you might know a face, but how can we find out information about who we're voting for?
Yeah, and all that when you know, like different forums that you have in terms of, you know, like Black Political Caucus of Charlotte, you know, does forums, but you have all the various political organizations, you know, put on forums. And so outside of just like going to those meeting and greeting, that's, it can be tough because a lot of times, you go to the polls and they just give you a sheet and you could say, hey, I don't know half these people. Like I heard North Carolina has the ninth longest ballot this election. We have the ninth longest ballot in the country. So they're going to be like plenty of people where we're like, hey, I don't know who these people are. So I'm going on someone else's recommendation as to who's the best candidate. And we, maybe like people, we got to do a better job of educating ourselves and helping to educate others in terms of, hey, for this particular race, this is who, should be the better candidate, based on this criteria.
Gotcha. So I guess kind of moving forward, I mean, I understand the importance and the need to continue to protest to bring awareness to the situation, what's happened, how things kind of played out, to help with understanding that certain things, certain laws or things that we have in place, we need to make sure that we're voting in a way that helps to correct or change or some of those laws, or at least helps us to better understand those laws so we know how to kind of act or present ourselves when we're put in certain situations. But at one point, is it possibly a judge's fault or someone from a superiority standpoint? Because I'm thinking you have these guys coming in, and this is a B team. I'm calling them the B team because this isn't the team that actually was part of the investigation for what was happening. These were people that they kind of put together to go in because the other group was going in to do some other or to serve some other no-knock warrant. So not only did they probably cause what happened or indirectly possibly cause what happened to Breonna Taylor, they put their own representatives, those police officers, in danger as well, by one, not having up-to-date information. If you're going on information that was a month, 2 to 3 months prior, and you're sending your individuals in with a no-knock warrant, and with no knock, you have no idea what's going to happen, what's going to take place. At what point are individuals that are the superior of the officers that have, I guess you could say, that serve the no-knock warrant, at what point are they responsible, or are they responsible in any way for some of those things that don't go the right way?
Yeah, and that's where where we get to of where something can be a civil violation and not be criminal. So a
Gotcha.
superior who says that, you can say, look, you allowed these officers to go out and you didn't have good intel. The most recent
Right.
information you had was 2 months prior. That violates policy. Because of that, you are going to be reprimanded, and we'll cite you for termination or some type of discipline. All those
Okay.
things can happen. It gets to, okay, well, what can you be charged with? Because like I said, under
Gotcha.
the homicide laws that they have, that the law doesn't apply to those facts. And it's just like the case we have in Charlotte of where Harold Easter died in police custody earlier
Right.
this year. And allegation was that he had ingested cocaine, and the officers knew he had ingested cocaine, and yet they left him alone for interview room. And so the chief of police can say, well, look, that violates policy. You all know that if someone has ingested a controlled substance, for you not to, leave them, you need to, do something or what have you. So they can be fired, but there's not a criminal charge that applies. They can't be charged with a homicide offense because they left them in the room. It doesn't rise to the level of involuntary manslaughter. So that's why the DA issued that letter saying why they couldn't charge them. But that doesn't mean that the family doesn't have some other recourse, such as if they wanted to file a lawsuit, if they haven't already.
Gotcha. So that makes sense. So that's great great breakdown for us there on that civil, that once again goes back to the civil versus criminal. So totally understand that. So well, I guess Robert, how do we move forward? I mean, as we look at this case, the decision that was made from a criminal side, and the fact that they did get have the settlement on the civil side. As a community, how do we move forward, and what can we take back, or what can we learn from this so that we can move forward?
Yeah, and I know it's a difficult conversation in terms of, because it becomes, you're saying, hey, once again, this is something that has happened in our community. Yeah, the Malcolm X Malcolm X quote that the black woman is the most disrespected person. So how, I heard someone say, in terms of even like with voting, how does that doesn't end in terms of racism or how people are going to like look at you. But I think it is has to be an ongoing process. There's no like salve. There's no easy or one fix. It's constantly looking at who we have, making these decisions, constantly applying pressure in terms of how they are making decisions and how they are policing our communities. I think only with those systematic changes across the board do you stop these types of things from happening. Of where you look at the letter of the law, then you can understand and say, okay, hey, I see why they aren't being charged. But like we said, there's so many things that happen on the back end that we need to put pressure on and have them change those policies.
Gotcha. Keith, did you have any thoughts on that, kind of how we can move forward, or any additional questions?
No, I think it's a tough pill to swallow, because while I understand the legal ramifications, it still doesn't feel fair or right. And I think we're seeing the results of those feelings in the protests that started right back up immediately after that was announced. And it's hard to tell people not to be mad when so many things have happened over a period of time, and we see things continue to happen. I'm looking back. I'm looking back over the 400 years since we've been in this country, and I think we as a people of color, and how long it took us to just get to a point, to this point. So it may take another 100, 200 years before things are truly equal, but we have to keep fighting for it. That's the bottom line, the way I see it. But we have to keep raising the flag. We have to keep saying something when things happen. We have to keep people's names in our mouth. We have to continue to remember, Breonna Taylor, and unfortunately, the next person, which is sad to say that there will be another. But we cannot let these things happen in vain. We cannot let their deaths be in vain.
Absolutely. And Robert, man, if you want to tee it up for us, kind of your closing thoughts or remarks, would definitely love to hear them.
Like I always say, whenever I get an opportunity, to speak to anyone, and we said in North Carolina, we have not had jury trials since March. We may start back November, but we may not start. But some people think we may not start back till the first of the year. And if you have issues with the criminal justice system and you don't think laws are applied fairly, serving on a jury is something that everyone over the age of 18 is entitled to do. It is giving back. It is a means of service, and is helping to hold law enforcement, DA's office, what have you, accountable. And that studies show that you have more equitable outcomes the more diverse your jury is. This is uncertain times. We don't like being around, or it's not, we shouldn't be around in groups, but as long as it is a safe situation and you are able to do it in terms of taking time out from work, then I encourage people that if you are called, then to serve and not try to get out of it.
Gotcha. No, that's great. I did have a quick question. How was a grand jury brought in, or where do those individuals or the representatives from a grand jury come in? Is it the same as a normal jury process for a criminal case or something?
On a grand jury, people who serve on a grand jury, it is a secret proceeding that you receive like the same notice. But if you are selected on the grand jury, then you serve on that grand jury from like 6 to 12 months. It's
Okay.
secret so that you don't have to worry about reprisal or saying, hey, these people are coming after me because I said the charges should be brought. And it's usually one-sided, and that the prosecutor doesn't have to present all the evidence. They don't have to present stuff that helps you. So with Breonna Taylor's case, we don't even know if they presented evidence on the two other officers, Cosgroves and Mattingly. I'm
Right.
assuming they didn't, since the AG said that they had already concluded they acted in self-defense. So they don't even have to present evidence. All they have to do is just present on Haskins and say, say this is what happened. And that's why I always say that if a prosecutor wants you indicted, you get indicted.
Right.
It's rare that they don't indict, because that's why people say you can indict a ham sandwich. You're only
Correct.
presenting the evidence that supports your case.
Perfect. And I want to close with that because that makes sense. So, look, at the end of the day, if the AG in Kentucky wanted this case to go to trial, then this case would have gone to trial. That's me speaking, and that's my
Oh,
personal.
no,
That's
that's
my personal.
absolutely true. If they
Gotcha.
wanted to indict, they would have gotten an indictment, but their review analysis concluded that the officers were justified.
Perfect. No, perfect. That was what my thoughts were, and where I was kind of going. So no, I appreciate you bringing that to light, and that's why it's so important to. It's a great segue. So important to vote. It's so important as Keith was saying, we have to dig deep. We have to understand the positions and those things that individuals are running for, and make sure that we vote. We get out to vote, and we get the right individuals. In the positions or in the roles that they're running for. Because if not, situations like this will continue to happen. So voting is very, very important. And I agree. You always bring up that sitting on the jury and the importance of the juror, and it really escaped me until you start bringing that up. That how important that is, and it's something that we can all do that sometimes we kind of take for granted. But I want to leave with that as well, of the importance of jury and jury duty. If you're called to, if you can, to make sure that you are doing just that, serving and making sure that you're doing your duty and serving in that role of juror. But Keith, is anything else you wanted to say or close with before we head out?
I'm just thinking of other questions, and I don't want to take us down a rabbit hole, but I think we're in a good spot.
Awesome. Well, Robert, man, again, we appreciate you taking the time to join us today, and kind of as we always leave with Teed Up Talk is faith forward with grace, mercy, and love. God bless, man. Y'all have a great one. I do appreciate it again. Thank
Hey,
you.
thank you. Hey, good seeing you brothers again.
Absolutely.